We are now transitioning into buyer-side representation forms. This chapter begins with one of the most important documents in modern real estate practice, the Buyer-Broker Exclusive Employment Agreement. As of the 2024-2025 industry changes following the National Association of Realtors NAR Commission litigation settlement, written buyer representation agreements are no longer optional best practice. They are required before a realtor may show a property to a buyer. The notice to buyer at the top of the form is clear. All realtors are required to have a signed written agreement prior to showing a home to a buyer. This change is directly connected to the nationwide litigation regarding buyer-broker compensation and transparency. The settlement required clearer disclosure that broker compensation is fully negotiable and not set by law, MLS, or any realtor association. Arizona's February 2025 form reflects that reform. Why this agreement is now: mandatory buyer representation, transparency. Historically, many buyers assumed the seller paid the buyer's agent automatically. The NAR settlement clarified that buyer-broker compensation must be negotiated and documented in writing between buyer and broker. This agreement accomplishes three major legal objectives: establishes a formal agency relationship, defines compensation clearly and negotiably, prevents undisclosed commission expectations. Gilbert. Example: a buyer attends multiple open houses without signing a buyer agreement. Later, two agents claim representation rights. Without a written exclusive agreement, compensation disputes become likely. This form eliminates that ambiguity. Exclusive and irrevocable right to represent the core of the agreement, in exchange for the broker's agreement to locate, negotiate, and facilitate purchase. The buyer grants the broker the exclusive and irrevocable right to represent them during the term. This means the buyer cannot use multiple agents simultaneously. The broker is legally protected in their representation. The buyer may be liable to compensate multiple brokers if they sign more than one agreement. This is serious contractual language. It is not symbolic. Term of the agreement time boundaries. Matter. The agreement specifies a start date and expiration date. Representation does not last forever. Professional practice. Standard. Shorter. Reasonable terms. Reduce buyer hesitation. Extensions may be executed if the relationship continues. Queen Creek. Example: a 90-day term aligns with a buyer's active search timeline. Employment obligations. What the broker must do. The broker agrees to locate property matching buyer criteria, negotiate at buyer's direction, assist within scope of expertise and licensing. This creates enforceable duties under Arizona agency law. Agency relationship defined. The form references the real estate agency disclosure and election form. This ensures clarity regarding fiduciary duties including loyalty, obedience, disclosure, confidentiality, and accounting. The agency election prevents later claims of confusion about representation status. Property viewings and first visit rule. Critical in the new compensation era. The buyer agrees to work exclusively with the broker and be accompanied on the first visit to any property. If the broker does not accompany the buyer, especially to a builder model home or open house, the seller or builder may refuse to compensate the broker. This is extremely important after the NAR settlement. Compensation is no longer presumed through MLS cooperative offers. Phoenix new build. Example: a buyer walks into a builder model without their agent present and registers alone. Builder refuses to pay buyer-broker commission. Under this agreement, the buyer may now owe the broker compensation directly. Education prevents conflict. Broker compensation, fully negotiated and transparent. The agreement states clearly in bold, broker compensation is not set by law, nor by any board, association of realtors multiple listing service, or in any manner other than as fully negotiated between broker and buyer in this agreement. This language reflects post-lawsuit reform. Compensation must be a fixed percentage, a fixed dollar amount, or another clearly defined structure. No ranges, no open-ended language. Seller-paid compensation, credit mechanism. If a seller or seller's broker offers compensation, it is credited against the agreed broker compensation. If the seller offers more than agreed compensation, the broker keeps only the agreed amount, and the excess is credited to the buyer, subject to lender approval. If the seller offers less, the buyer may request seller payment in the purchase offer, and if not covered, the buyer pays the difference. This is one of the most significant structural changes in modern real estate practice. Failure to complete and good faith obligation. If a buyer breaches the purchase contract or prevents completion outside of contractual rights, the broker compensation may still be owed. This prevents buyers from using brokers extensively and then intentionally walking away outside contractual protections. Protection period. After expiration. The agreement includes a post-expiration protection period. If the buyer purchases a property shown or negotiated during the term within a defined number of days after expiration, compensation is still owed. This protects brokers from buyers waiting for the agreement to expire and then purchasing directly. Release of broker and limitation on advice. Just like the market conditions advisory, this agreement states that brokers do not provide financial, tax, or legal advice. Buyers are instructed to independently investigate third-party professionals. This reinforces Arizona license boundaries under AAC R428-1101. Alternative Dispute Resolution and Arbitration Clause. The agreement requires mediation first, then binding arbitration unless opted out within 30 days after mediation. Class action waivers are included. Arizona law governs. Attorney fees may be awarded in non-realtor compensation enforcement proceedings. This is a legally binding dispute resolution structure. Why this form protects buyers and brokers in 2025 and beyond. The NAR litigation changed buyer representation nationwide. The buyer-broker exclusive employment agreement now ensures transparency of compensation, written acknowledgement of negotiation, clear agency relationship, defined risk allocation, reduced commission litigation. This form is not a commission protection tool. It is a consumer transparency document aligned with federal antitrust reform requirements. Course discussions with answers. Discussion question: why is a written buyer representation agreement required before showing property in 2025? Answer: because post-NAR settlement reforms require written agreements establishing representation and negotiated compensation prior to property showings to ensure transparency and compliance. Discussion. Question: if a seller offers less compensation than the agreed broker compensation, who may be responsible for the difference? Answer: the buyer may be responsible for paying any portion not covered by the seller or seller's broker. Discussion. Question: why does the agreement include a protection period after expiration? Answer: to prevent buyers from circumventing compensation by waiting for the agreement to expire before purchasing a property introduced during the term.